Hi, in the last session, we looked at an overview and what changes the Hindu Minority Act and Guardianship Act 1956 brings in. In this session, we will do a deep dive on guardian as defined in the Hindu Minority and Guardianship Act 1956. There are five categories of guardians as defined. One is natural guardian, then we have testamentary guardian, guardian appointed by court, de facto guardian, and ad hoc guardian. These are the five categories which we will get into a little more detail in today's session. Starting with the natural guardian. The natural guardian is one who becomes so by reason of his natural relationship with the minor. Section 6 of the Act gives a list of guardians as a boy or an unmarried girl, the father, and after him, the mother, provided that custody of a minor who has completed the age of 5 years shall ordinarily be with the mother. That's the way it is defined. The second is related to illegitimate boy or a girl. In the case of an illegitimate boy or illegitimate unmarried girl, the mother and after her the father is the natural guardian. In case of a married girl, the husband is the natural guardian for his minor wife. There are some restrictions imposed as per the Section 6 in the Act, and it says the person cannot act as a natural guardian if he or she ceases to be a Hindu, or if he or she has completed and finally renounced the world by becoming a hermit. There are certain powers of a natural guardian which are defined in Section 8, respect to minors, person and property. The guardian has the power to act on behalf of the minor if it is necessary or reasonable and it acts on the benefit of the minor. The guardian can act if the act is in the benefit of the estate. The guardian has the power to enter into family settlement on behalf of the minor as well. There are certain powers of alienation given to the guardian. Natural guardian has the power in the management of the estate to sell or mortgage any part if necessary, but has to take permission of the court under Section 8, Clause 2. He can, with permission from the court, mortgage or charge or transfer by sale, gift, exchange, or otherwise any part of immovable property of the minor. He can also please any part of such property for a term exceeding 5 years or for a term extending more than 1 year beyond the date on which the minor will obtain majority. That's what is are the basics of, let's say, the natural guardian as defined in the Hindu Minority and Guardianship Act. Now let's look at the second one, which is testamentary guardian. The testamentary guardian of a minor are those guardians who are appointed by a will of the natural guardian entitled to act as a guardian for the minor. It is noted that a will become effective only after the death of the executor. There are certain powers of a testamentary guardian defined in Section 9 of the Act. It basically says a Hindu father entitled to act as a natural guardian of his minor legitimate children may, by will, appoint a guardian for any of them in respect of the minor's person or in respect of the minor's property, other than the undivided interest which is referred to in Section 12 or in respect to both. An appointment made under subsection 1 shall have no effect if the father predeceases the mother, but shall revive if the mother dies without appointing by will any person or guardian. A Hindu widow entitled to act as the natural guardian of her minor legitimate children, and a Hindu mother is entitled to act as the natural guardian for her minor legitimate children by reason of the fact that the father has become disentitled to act as such, may or by will appoint a guardian for any of them in respect of the minor's person or in respect of the minor's property, other than the undivided interest referred to in section 12 or in respect of both. A Hindu mother is entitled to act as the natural guardian of her minor illegitimate children by will appoint a guardian or for any of them in respect to the minor's person or in respect to the minor's property or in respect to both. The guardian so appointed by will has the right to act as a minor's guardian after the death of the minor's father or mother, as the case may be, and to exercise all the rights of a natural guardian under this act to such extent and subject to such restrictions, if any, as are specified in this act and in the will. The right of the guardian so appointed by will shall, where the minor is a girl, cease on her marriage. So these are the four, let's say, powers which are given to, let's say, the testamentary guardian. The next one is guardian, which is appointed by court, where the court is satisfied that if for the welfare of a minor, that an under should be appointed a guardian of his person or property or both. The court may make an order under the Guardian and Wards Act 1890 and can appoint a guardian. There are certain guidelines given in terms of who can apply to be a guardian, which primarily are a person desirous or claiming to be a guardian of the minor. He can be relative or a friend of the minor, the collector of the district or other local areas in which the minor resides or holds properties. And if the minor belongs to a class, then the collector who has the authority with respect to that class can become the guardian of that minor. There are powers of a guardian appointed by the court, power of the guardian appointed by the court, and control imposed by the act over such powers are the same as that of natural or testamentary guardian. There is no difference in terms of the powers of the guardian, irrespective of whether the guardian was appointed by court or whether it was through a testamentary guardian or a natural guardian. The next one is de facto guardian. A de facto guardian of a minor is the person who himself takes over the management of the affairs of the minor as if he was a natural guardian. He is neither a legal guardian nor a testamentary guardian nor a guardian appointed by a court. And the last categorization of the guardian is the ad hoc guardian. When a person acts as a guardian of the minor for a temporary period or for a single transaction, he is called a guardian ad hoc. He is not recognized by as a de jure guardian. An ad hoc guardian does not have any fixed place in the act, and any alienation of minor's property by him would be void. So these are the categories of the guardians as defined under the Hindu Minority and Guardianship Act 1956. There are some generic provisions related to guardianship, which are a must to know. For example, Section 10 says minor cannot act as a guardian of any other minor. Section 11 says that de facto guardian is not entitled to dispose of or deal with the property of a minor. Section 12 says that no guardian can be appointed for a minor's undivided interest in the joint family property. And lastly, Section 13 provides that the court, while appointing a guardian, must give maximum consideration to the welfare of the minor. That's all which is related to the details of the categorization of guardians. You can download this presentation from www.juristknowledge.com. Thank you.